All right. Hi, everybody. I'm just waiting for a couple more people to come in. Let's give it a minute and then we'll get going. Okay. Well, let's get going then. So first thing I'd like to do is thank our sponsor, Atrons Council. Very much appreciate sponsoring this webinar. And of course, we appreciate the Canadian chapter of the Community Associations Institute for putting on this webinar and making it possible. So with that said, I'll move on to the slide that you just accidentally saw, which is the title slide for the presentation, Dispute Resolution and Prevention for Condos and Strata. And I put the Beatles here because of their song, We Can Work It Out. I checked and we do not have the budget to play it, and I do not know how to sing it. So you're just gonna have to enjoy this photo. Moving on from there, we have, I will introduce the speakers. So my name is Gerry, I'm your moderator, but the real key to today are the two speakers that we have. So the first one is Christy Allen. Christy's a partner at Davidson Houle Allen, and she provides a full range of litigation services. Christy's work includes building deficiency actions, proceedings involving difficult owners and tenants, which we'll be talking about today, collection and lien proceedings, including power of sale, as well as matters involving the enforcement of property rights. So Christy is a good one to have on this webinar, and thank you for joining us. The next one, the next natural to be on this webinar is Colm Brannigan, mediator and arbitrator in the Toronto area. And he is a fellow and chartered he is a fellow of the Chartered Institute of Arbitrators. And Colm holds a master's degree in alternative dispute resolution. And he has spoken at and taught at webinars, programs, and conferences, including ones at the Faculty of Law at Queen's University. So Colm, thank you for joining us as well. So our first slide here, getting into the topic, preventing conflict and civility, and what does civility mean, and why am I bringing this up at all, right? So we have this handy dandy graphic here that shows two different ways of picturing civil society, right? So on the left, you have this idea sort of that civil society is in its own bubble, and yes, it affects these other circles, and there's some arrows back and forth, and maybe it has something to do more so with state and the political sphere, because that line is bolded, which looks serious to me. But is this a way is this the way that civil society really works? Is this its real function, right? Because on the right here, we have another way of viewing it. And civil society on the right is sort of the glue that keeps these other circles together, right? And so my way of picturing this sort of is that without civil society, these other areas don't function well. And if you think about everything you've done through your day, probably almost all of it, if not all of it, more than likely was done civilly, right? You bought some gas or some lunch or a toothbrush or whatever you did, and you probably didn't get into a big fight with that other person. And if you did have some kind of disagreement, we're in Canada, I bet the other person apologized and you just moved along, right? So I guess, Colm, maybe I'll start with you. Is it sort of our duty, or should we be mindful as we go through the day about keeping civil society together to not burden these other spheres? What do you think about that?
Well, I think this is a really interesting diagram of civil society, and I plug into it slightly differently. I mean, if you look at it and you take out civil society and you put in condos, the condo has a political sphere, an economic sphere, and a family private sphere. So this is a great diagram. And so what we would do in day-to-day life, we hope, is that we would behave in a civil way, and that we would try and both prevent and manage conflicts as well as resolve them. But it's very difficult to say, and my apologies if there's any noise coming through. I'm having some work done outside that I can't do anything to stop. But yeah, I think that diagram sums it up nicely.
Christy, I mean, you deal with disputes all the time. And how would your day look if we had a system that encouraged disputes rather than a system that is trying to get people to be civil with one another at the outset? What would that even look? I don't want to give you nightmares, but what do you
Well,
think?
I don't want to give the viewers nightmares either, but there would be a heck of a lot more lawyers out there, which is a scary thought. So, yeah, I think that where you remove the civility, and that basically removes sort of the influence to remain somewhat reasonable, and removing a little bit of the emotion from situations that we encounter, which allows us to deal with them a little bit more effectively. So yeah, certainly a society that encouraged dispute. I can't imagine it. We have enough disputes as it is, and we live arguably in a civil society. So yeah, I like the diagram on the right much better than I do the diagram on the left.
Right. So I guess that, and the reason I bring all this up too, of course, is that a common theme throughout this is going to be how to appeal to civility and to prevent a court of equity. I'm not going to get into the whole history of that, although it would be fun. But just to point out that equity and not
Gerry, we seem to be having some tech problems here.
We're losing you, Gerry. We may be able to just chime in on this slide, I think, a little bit.
Yeah.
Can you hear me okay?
Now, yeah, but
Okay.
you are kind of breaking up and freezing a bit.
Yeah, my 4-year-old's probably playing Nintendo. I don't know what happened there. Sorry.
No problem.
I will just say that I won't go over exactly what I just said. Then this photo is meant to grab your attention and to point out that equity has been a long-standing issue in society, both for lawyers, judges, and of course people who are subject to the decisions. And so I thought it would be fun to discuss. Of course, it's not a court of equity you're going to go to, but how do equities play into conflicts today? And so, for example, maybe Christy, you could talk about what about costs? Like, our judges, if you have to go to a judge or an arbitrator, and Colm, of course, we'll get you to weigh in later too. Is it your experience that the more reasonable people are, the more likely they're to be awarded costs or anything like that?
Yeah, I feel like that's a loaded question. Yes. But the truth of the matter is that it is the case. It's not in every case, but generally speaking, I mean, the rules in court in particular around costs, and then I suppose the same arguments would be made from an equitable perspective in the context of arbitration. The rules around that are ingrained into our court system basically tell us that if we are prepared to behave reasonably and take reasonable positions, then we are going to be rewarded by being awarded additional legal fees if we are ultimately successful at the end of the day in the hearing process. So certainly there is a connection, and it's a real connection. It's not just in concept. There is a real connection between acting reasonably and recovery of costs. Again, it's not, every case is slightly different because obviously every case, the facts are going to be different, but ultimately, because costs are always going to be within the discretion of the decision maker, they're permitted to take into consideration things like behavior and conduct throughout the proceeding and in advance of the proceeding.
And Colm, when you're arbitrating, mediating, what do you look for?
Well, I think I look for reasonableness, and equity has several different meanings, but to me, it's, almost fairness. How are people treating each other in it? And, I think that's extremely important in the condo field, because condos need healthy ongoing relationships among their stakeholders. And, we're very good at dispute resolution in terms of the legal system. We're not so great at preventing disputes getting there. And I think that's where the opportunity lies. And there's a huge benefit to that. So, you look at how we approach communication, how we approach, the idea of being respectful of people who you might not agree with. Those all pay off at the end. Because remember that the Condominium Act requires directors, they have a duty to enforce, bring about compliance, but that duty is a reasonable duty. It's not necessarily 100% one way or the other. So I think that's something we have to keep in mind, and that's difficult when things are heating up. But the condos are just, because of what they are, communities, because of how people value their homes, they just need a little bit of a different approach. And that includes what Christy was saying, try and be reasonable if you can. And it really impacts on costs. One of the things I see as an arbitrator and sometimes a mediator, but mediators can't impose anything. Now, although the Condominium Act's got a weird provision about mediators being able to award costs, which to me is not what mediators should generally be doing, because mediators don't make decisions. They facilitate the discussion. But if we go into the next stage where I would be involved, similar to Christy in court, arbitration does require me to look at who wins, who loses, and then assess the cost aspect of it. And one of the things that I do, because I get all this stuff, I get copies of the letters and the emails, and I do look for people being reasonable. I think it's really important to be able to show anyone making a decision in court or arbitration that you've made a good attempt to resolve it outside before you got there. And so I look at that. And so if you were a condo and you took a very harsh approach that wasn't necessary, although technically you were right, I would be unlikely to award you a high level of costs. I might award you some costs because you won, and the other way around. If you were a condo that had a very, very difficult unit owner and you had to, you tried to pull them into compliance instead of trying to push them, and you did all the right things, write letters that invite them to participate in finding a resolution, to me, that would justify a higher cost award against the unit owner who, behaved in a bad way. So it's incumbent on both sides to be reasonable if you want to recover your costs, especially, but also if you want to get the greatest opportunity to resolve the matter, to manage it and resolve it.
I think it's a good point that, sorry, I just wanted to jump in quickly to pick up on something that Colm had mentioned about his role in reviewing communications. I think that that's a really good point, because I think it highlights the importance of the tone and the approach that you're taking in your communications. It's good to remember that whatever those communications are, they may end up before a decision maker at some point in time. And so all of the emails, all of the letters, as well as verbal correspondence, so meetings or discussions that take place, all of that is at some point going to be before a decision maker if the matter escalates. And it's going to become relevant, how you approach the problem and to what degree did you try to bring some reasonableness into it or attempt to de-escalate rather than escalate the situation.
So when you're writing communications, a couple things to take in mind are that someone else might read this eventually. Someone might not be happy with it eventually. And there's an economic incentive as well. So it sounds like my form letters usually have a big red notice of violation on the top, and then it's a picture of me sort of scowling. that I'm going to have to change that up, I guess, then.
You probably should.
Yeah.
Okay.
Yeah.
I
That's
think
not recommended.
Yes, yeah. But if you're happy with it, that's fine. I think we need to learn from the workplace. In workplace issues around, terminating workers, I mean, what happens is there's progressive discipline, a warning, a stricter warning, and then, the third letter. And I think we need to adopt that approach, because what happens now still, although not quite as much as it used to, is that the property manager writes to the unit owner, and we're just looking at unit owner type disputes here. And the letter is demanding compliance and generally setting out rules, bylaws, declaration, which the owner may or may not know about. And then the next one escalates, and the next one's the lawyer's letter. And the lawyer's letter, similarly, because it's legal, is legalistic, and none of them invite the person into a conversation. They demand that the person do something. And you get a lot more by trying to pull someone in than you do by pushing them. And so that's keep in mind. And some of them are terrible. And to be fair, I'm not trying to be on one side or the other, but some letters written by unit owners are terrible as well, but they bear the same risk, that they're successful and don't get costs, or that it escalates, that you lose the opportunity. Your letters upset people, and therefore they don't take the opportunity to resolve. It's something we have to be a bit more careful about.
Right. So this is good advice for anybody in sort of a conflict about almost anything, but including condos, no matter who the party is, which actually segues into something you were just saying there, Colm, segues into this slide nicely, which is typecasting. And by that, I mean, and I picked 3 actors that I could only think of roles where they play bad guys. But of course, this could also apply to actors or actresses who always play good characters too, right? We get into our mind a certain set of characteristics for certain unit owners, managers, board members, whoever they might be, and then we sort of read into what they're sending to us, what we think they're going to send to us, without reading an unbiased way the content of their messages sometimes. And I guess, Christy, when you are counseling a board, for example, or a manager, because obviously managers fall prey to this maybe as much or more than anybody else, how hard is it to carefully read what like an invidious message says and then have to go, oh, they might have a point? Does that happen, or how do you break that to people?
It does happen, and it's really difficult because often by the time I see something, things have escalated and both sides are sort of entrenched, and there's emotion involved. And so it's difficult to counsel a board or a manager to remove the emotion. I mean, it's a difficult thing to do, and it's certainly a difficult thing to advise on, but it is important, as much as reasonably possible, when receiving communication from individuals, even if they're the most difficult individuals in the condominium, who are, the ones who are always complaining or always creating issues. It's always important to look at communication as objectively as possible to assess whether or not there's any merit to what is being raised. I see this quite a bit in the human rights context. There's other contexts as well, but that's just one that pops to mind, because it can be, it's a sensitive area. Often the people who are requesting accommodation or who are dealing with disabilities, who require accommodation, they may be coming at the problem from a different perspective than the manager and the board. And it's so, as difficult as the individual may be to deal with, whether that's not, I'm not saying it's always the case. It's just, I've seen it a couple of times in the human rights context where I've had to advise a board or a manager that in fact, the individual has a point and has some rights that need to be respected and need to be addressed, even though the individual is hostile, argumentative, really difficult to deal with. We still have to ensure that we're recognizing their rights and ensuring that whatever the required accommodation is implemented for them. So that's a scenario where, again, if you can take a step back and look at the situation and perhaps consider the motivation of the individual, the intention of the individual, rather than just looking at the words. The words can hurt sometimes and can certainly escalate rather than de-escalate a problem. But taking a step back, looking at the issue as objectively as possible and assessing what is actually being asked for here, leaving aside the arguments, leaving aside the anger. What is it that's being requested here? And is it something that's fair?
And Colm, thanks, Christy. Colm, when you're dealing with mediations or arbitrations, do you see this type of thing happening a lot?
I see it happen enough.
Enough?
Not a lot, but enough. And I think we'd be very careful, because what we need to do is, I think, rather than look at certain behaviors being bad behavior and they're a bad person, I think we need to look at it as a barrier to communication and everything else. And how do we get through that? Well, we use our communication skills, we use negotiation skills, we use mediation skills. Now, some people you just can't, reason with. And as the mediator being, neutral, impartial, I mean, I can see how some people rub people the other wrong way, even though I'm not, going to be judgmental about it. I think what's incredibly important, just reinforcing what Christy said, is don't jump to bad faith. Don't think just because the person is difficult that they're acting in bad faith, because from their side of the story, and remember, that's what we're talking about. I mean, some people tell me story is not a good word because you're making up stuff, or you say perspective, but I think it's a story. And the story, it looks quite different depending which side of the table you're on. So the number one rule here will be the same as everything else. Take a minute, count to 10. Don't ascribe, bad motives to bad behavior, because the bad behavior may be driven by something that is just so important to the person that they can't behave in a reasonable fashion till they recognize they're being listened to. And that is also the key, where property managers come in as well, is being able to listen and de-escalate rather than having going up. But you should try to de-escalate at every stage.
Yeah, and something I've noticed that I hinted at a little bit too is that I have seen this work in reverse, where people have such a good opinion of somebody. Well, he's such a nice guy, or that director is, my neighbor and they're wonderful, that when they break the rules, nothing is done, which of course leaves you in a weird spot as a condo where you're not intentionally picking favorites, but that might be the outcome anyway. And so I am aware of the Ribeiro case that we spoke about yesterday when we were discussing this, where the judge admonished the condominium for not upholding the same rules for everybody, even though it was acknowledged that, yes, maybe one unit owner is a nuisance more often. If somebody else does something wrong, it's not an excuse either. Would you say that's a fair thing to watch out for as well, Colm? Or?
Definitely. And I think that goes back to the idea of consistency. You have to be consistent in how you enforce and how you treat people. And the courts, do give us some guidance, and that's Christy's area. I mean, I read the cases, but only out of interest. But, I don't necessarily understand them all. But one thing that's clear is that there's been a huge shift in the last 10 years in how courts see condo behavior, condo costs issues, and what you should and shouldn't be doing. I mean, remember, reported cases are generally good examples of what you shouldn't do rather than what you should do. So there are messages in those. And one of them, I think, is make sure you do the same thing with all people. Be consistent. Treat all members of your community the same way, even if you don't like them. You just got to watch that, because that's a huge escalator. And yeah, sometimes, oh, I think so-and-so so nice, and it's going to be great, and it isn't, because we're dealing with such important issues to the people who are in conflict or in a dispute. So yeah, this is a very good one, because this is really difficult to do. I mean, basically, dealing with somebody who rarely enjoys conflict, but some people bring into conflict mental health and other issues. So again, we have to be very careful on this and know when, I think, to ask for outside help, and that might be a board getting the property manager more involved. It may be the board and the property manager asking for legal counsel. If any issues around human rights or mental health come up, they're very difficult to work out in mediation, and it's exceedingly important. I mean, they can be if you take your time, but we're all in a rush. It's very important that you get expert advice from your lawyer and from your property manager. I mean, I think the initial analysis of the dispute, a bit more time should be paid to that. And if necessary, that might be the time to get the expert advice before it escalates, because some things are worth escalating and others, quite frankly, aren't. And I think talking to someone else, a third party, may help you with that. But don't typecast. Although we all do.
Did you have anything to add to that, Christy, or did Colm nail that one?
I think he's pretty much nailed it. I think, yeah, the message that we should refrain from typecasting is definitely a good message. I mean, I think one way to do that is to, when receiving a request or demand from an individual that maybe there's a history with, maybe is a difficult person in general, is to consider what the response would be if the request was coming from someone that you didn't consider. So someone that was, a sort of a model resident, if the request was coming from them, what would the response be? Just to double check that the response is actually objective and is not based on typecasting.
And just because somebody made a complaint before that was unfounded, or they were doing something wrong before, doesn't necessarily mean they're doing something wrong now. So if, what Christy said just makes such good sense. And yet we often see people not being able to do that. Now, there's no standard perfection, we're all human. But if you make a wee bit of an effort and stand back, I think you can have a much better community.
Yeah.
So a lot of this dovetails nicely again into techniques, right, for preventing conflict from escalating. We're gonna get further into where you can go as the conflict escalates, but it's nice to not let it escalate at all. So we have a few methods here that we've already mentioned, right? So avoiding prejudice, but there are some other ones in here that we haven't talked about, like something else maybe one could do if one is wondering whether there is a legitimate complaint or if a person's just being unfair, is to reword that complaint or summarize it to oneself to see if it makes sense. I imagine all of these techniques, Colm, are used in mediating or observing nonverbal behavior, showing interest, that sort of thing.
Yeah.
These can be used anytime, I take it.
Yeah, I think the really important thing is to listen. It's called active listening for a reason. It actually means more than just sitting there. It means listening to what people say. If you don't understand it, get it clarified. Be careful using closed questioning, because people will think they're being cross-examined if they have to go yes or no. The open question gets you more information. Observing behavior, it's been interesting in the last couple of years because we're doing everything online, and many people were concerned that because nonverbal actions are so important that would be hindered by being online. And in fact, in many ways, it's made it easier because there's all kinds of micro expressions in your face and you see the person's face clearer. But look for the things, that you would have in any conversation, and just be open to listening. And we're not very good at listening. We jump to solutions. Okay, people need to tell you what they need to tell you before you can solve their problem. And sometimes they need to tell you way beyond the point that you knew how to solve the problem. And I think for boards and property managers and lawyers and mediators and arbitrators, you have to be very careful that we kind of, when we're speaking to people, we put down the expert cloak. We're talking to people as people. But to me, the main thing is to listen.
Yeah, I have to admit, sometimes if I had to say what my biggest problem was when listening, is that, Colm, like you said, if I think I've gotten something after 2 minutes and the person is still going, my knees start to shake and I'm thinking about the next thing I have to do. So that's something I've got to work on. But you know what, that's good advice, because I'm sure everybody who's that, if you've received the same question 100 times, for you it becomes natural, but for this person it's still the first time, right? So Christy, did you what do you think about active listening? I mean, this must help even when you're dealing with an opposing party in a lawsuit or anything, right? I mean,
oh, absolutely. Yeah, I think one of the best things that I can do in a situation where I'm dealing with a dispute is take the time to try to figure out what the motivation is. Because once you understand what the motivation is, it's easier to figure out where you've got sort of a realm of potential compromise. And the only way to really figure out what the motivation is through active listening. Often the motivation is completely hidden, like whatever the real concern is behind the complaint or the dialogue that's ongoing. It can sometimes be hidden, especially if there is a lot of anger or emotion involved in the communication. And so having a discussion where you're actually listening to where the issue is coming from, what caused the concern or the dispute for that particular individual, and what it is that they're actually trying to achieve. So they may be, you know, I just like angry towards the board, criticizing the board. Well, what is it that you're hoping to achieve here? What is it that you want changed? And only by understanding what that motivation is, you can really get to the point of getting to an outcome that might work for everybody. Another thing I wanted to mention on this slide was, and this is just a really, Colm actually mentioned this earlier, but it's a technique I use all the time. When I get an email, and I will tell you, in the realm of dispute, like lawyering, we deal with unreasonable counsel too. So it's not just boards dealing with owners or managers dealing with owners. We deal with excessively unreasonable counsel from time to time. I'm sure other lawyers would say that about me too, but maybe in certain circumstances. But when I get an email that is relatively aggressive and maybe personal in nature, which really gets my back up, I have to take time before responding, and usually I need to sleep on it. But I will say what I sometimes do is I draft something in response immediately to get it off my chest. But I'm just really careful not to hit send on that, because inevitably the next day I feel very differently about how it is that I can address what's being said here, and what might be more effective in terms of resolving the dispute, rather than making it far worse and just engaging in the anger and hostility.
Christy, it's funny you say that. This is just happened to me within the last 2 weeks, where I opened up my inbox and found an email from a unit owner telling me I was just the worst person ever, not just the manager, just a terrible human being. I deserve to be fired and all this stuff. And then I noticed another email came in just about an hour later from the same person, and it said, "Gerry, I'm so sorry. I never meant to send that. This is something that I do to calm myself down. I don't feel like that at all." And I thought, well, this has resolved
hilarious.
itself nicely.
Yeah.
So you're not the only one doing that, Christy, where you write out a draft email.
It's a good technique.
Yeah.
It really is a good technique. And Christy, no one's ever told me you were unreasonable.
Oh, well, that's good.
There you go. But it is important that we take the time to do it. And of course, remember, once you go outside the condo community and the manager, and you bring in lawyers, there's an extra layer to the dynamic, as Christy was saying, between the lawyers and the parties. And for lawyers, when I'm speaking with lawyers about mediation, I say, well, you know, if you're not sure the person's being nasty or not, pick up the phone. You'll be able to find out pretty quickly, rather than write it back, because that email will find its way into the materials for sure. Now, if it's great if it's from the other side, because you can go, look how unreasonable they are. But it's not so great if you respond to it in the kind.
That's right. Okay. So preventing conflict, budgeting, and economic decision making. So we have two things here that we've discussed. One is that a lot of condominiums don't budget for legal or mediation or any sort of conflict resolution amounts. And then the other thing is using sort of economic thinking about to decide when it's appropriate to escalate something or not. So maybe, Colm, I'll get you started on the budgeting issue, if you don't mind.
Okay. Well, I mean, I think it's something its time has come, and probably came a long time ago, to build in a line item for dispute resolution and legal fees. We don't, and we do for auditing, and we do for everything else. And yet what happens is, if it is there, it's a very small amount, it gets used up, and then there's a real reluctance to get advice. I'm not talking about, you know, hiring the lawyer and going to fight. I'm talking about getting advice, because often the disputes that I mediate and arbitrate, if they had a different pathway, they mightn't have got in front of me. So I think it needs to happen. You know, we know that the cost of legal process is very, very high. In an arbitration, it's not uncommon, especially with smaller condos, for them to have to special assess to cover the arbitration fees. Now, that should put some fear into people, and it really strengthens the idea of, you know, get advice, which path you go down. Don't go down off one path without thinking about it. And I think, again, that's a really important role of your property manager, is to essentially say to the board, you know, maybe we should be talking to Christy. Right. But we need to do this.
Yeah, in my experience, a lot of boards, like you said, Colm, they keep a few $100 for that compliance letter that they think they might have to send, and you know, when they do need advice, there isn't a budgeted line item for various reasons too. I mean, I know that people are sensitive about raising fees, but good advice can also save you money. So, and with that in mind, Christy, in real life, this is something, not that this isn't real life, I guess, outside of webinars, this is something we've discussed before on a practical level, which is sort of economic decision making, but when it makes sense to escalate a dispute and when it really just doesn't. And I'm wondering if I could get your thoughts on what you see about, like, so for example, we've had some instances where there's a small claims dispute and we might offer a bit of money just to have somebody go away because it doesn't make sense to continue, or just that sort of behavior. What are the pros and cons, and what have you seen?
Yeah, well, the economic analysis is really important. Like when it comes to a legal dispute, there's the principles or the merits associated with the dispute. And then there's the economic reality associated with that dispute. Ultimately, if pursuing a dispute is going to cost the corporation more in legal fees than it would to just resolve it at the outset, that's something that I think is a really important factor for consideration for a board. And again, going back to our earlier discussion, I think part of that, the ability to assess the situation sort of purely from an economic perspective, requires a board to take a step back and disengage from the principles and disengage from the emotions around that, which can be really, really difficult. But again, you know, the interests of the corporation may very well be best protected by making the decision that makes the most economic sense in the circumstances. There may be other factors at play, like the precedent-setting value of the matter, the impact on other owners that may give rise to other claims or complaints from other owners if we resolve something with this particular owner. So there are a variety of factors that are going to come into play, but certainly the economics should be a big factor. And I think it's important at the outset to look at what all of the potential outcomes are from an economic perspective. So if you win on principle, what will be the cost of that win versus what will you recover, especially if you're dealing in small claims court where the recovery is minimal. If you lose, what are the consequences economically? What if you settle now for either the full amount or for maybe something less than the full amount that's being claimed? Will you ultimately save money in the long run if you can avoid that process and the costs associated with that process? So I think that assessment is particularly important, especially when you're dealing with small claims matters and CAT matters, because you're not going to necessarily recover your legal fees if you are to pursue it. So legal fees in particular are going to be a live issue for you.
Right. Did you have any thoughts about that too, Colm? Or?
Yeah, I think it's difficult to get there, but you have to. Risk analysis is key, and the earlier you do that, the better. So getting your counsel involved makes sense. But there's a couple of other things. It's difficult to do that, and the same with budgeting, because we can't value the dispute that didn't happen. It was avoided or is properly managed. We know what it costs when it goes through the process. I mean, oh my God, look at the costs. But we can't value all the other disputes that might have come up. And so that makes it hard to make those kinds of decisions. So I think we have to look at it. So the professional help issue, it's going to be very hard to do risk analysis on a legal case without having your lawyer's input. And there are different ways of doing that, but you know, most people don't want to go to court unless they have what they think is a 70 or 80% chance. And yet if both sides think they have that, somebody isn't doing the risk analysis very well. So, you know, you need to really think about it at the beginning. I mean, I see that a fair amount, but if we could move to doing this, I think it would be helpful. The other thing that I think you need one of the reasons to get professional advice, apart from all the others on a dispute, is within boards, and this is common with many organizations, there's an issue around responsibility and reputation. And so people, not unnaturally, are reluctant to make hard decisions. And they would prefer to have a decision maker take that place. I think we have to be careful about that. But that makes sense. You don't want the reputation that the board rolls over, but neither do you want, as was said earlier, you want to pick your battles. You don't want to waste a lot of money, and you don't want to cause real issues in the community, because there are huge benefits to resolving problems cooperatively. Just before we go on from that, I'm not a mediator who says don't litigate. Some do, I don't. I think litigation or arbitration, I could hardly say about arbitration when I am an arbitrator, but I think there's a place for those, but it should be a place that we get to knowing where we're going.
Well, you're leading into the next slide, which is court. So you're saying you don't say don't litigate, and we're saying that there are instances where you might want to litigate. Did you want to keep going on that train of thought, Colm, about when it might make sense to litigate, what the pros and cons are?
Well, I think, if the range of outcomes is just not acceptable, that you can't compromise to that degree. But also it may be, if you're looking to set a precedent, you would go. And I'll have Christy speak to the real serious issue in condos, and why court's an option is, around danger and that type of behavior. I mean, even now and then we see cases that are put out as they're an oppression remedy, and then people think it should go to court. But really the reason they're being put out there is to get out of having to mediate and arbitrate. But oppression remedies can go through mediation and arbitration as well. But there's some things there's a danger to, a real risk, and those are the ones that definitely need court intervention. But Christy's got way more experience than that. I don't see those, because when I mediate, people either resolve or they go on. And, I do follow up sometimes, but I generally don't see what happens unless it's a reported case. So.
Yeah, more and more compliance issues are being handled either through mediation or arbitration, or the CAT, the Condominium Authority Tribunal. But when a condominium is dealing with compliance that raises risks or concerns around the safety of other residents or of the property itself or the individual themselves, then court is where the dispute needs to go. And certainly it's something that the legal fee assessment, the economics, of course, it's going to come into play in terms of budgeting, but the corporation would have a duty in those circumstances to take action to address the unsafe circumstances. And so all of those thoughts previously that I mentioned previously about weighing the economies, it becomes less of an issue when you're dealing with that kind of issue, a safety issue, because the safety has to be paramount, and the Act confirms that it is paramount.
Now, if I remember correctly, and correct me if I'm wrong, because I don't deal with this very often either, the corporation's costs are indemnified if it's an oppression remedy. Is that the case?
If it's an oppression remedy, if it's a compliance issue through the courts. Yeah. So if you're dealing with a compliance issue, there's a provision in the Act that basically says if you are successful in obtaining a compliance order against an individual, then the condominium corporation is entitled to all of its reasonable legal fees, including those that are awarded by the court. So even beyond whatever the court orders as payment owing from the non-compliant resident, the corporation is entitled to recover all of its fees. And so that's confirmed right in the Act.
So that must make it an attractive option for condos, but I'm sure that it's not that easy, right? To get that done.
No, I mean, there's going to be the very clear cases where there's just it's clear and overwhelming that there's a safety issue, and the court isn't going to hesitate in making an award and recognizing the corporation's rights to recover 100% of its costs. But there are less than clear. A lot of these situations involving safety are not overwhelmingly clear. There's some gray zone. And so notwithstanding what's in the Act, there's always a risk, like the court does retain discretion on costs. And it can become a bit fuzzy when we're trying to rely on the provision in the Act that allows us to recover 100% of our costs if the order with respect to compliance isn't a clear-cut order against the individual confirming they've not been complying with their obligations.
And, you know, arbitrators tend to award higher level of costs when, you know, when asked to do, and there's a reason to do it. But courts can order full indemnity. And it's interesting, I arbitrated a case that was appealed and went through several other iterations. But at the end, on the costs issue, the court, I awarded fairly high costs. The court awarded 100% costs. They were so upset with the person's behavior. You know, I was trying to, it wasn't the worst of the worst. So I think I probably said about 90% of the costs, and the court made it 100%, which I found quite interesting in the reasoning behind it. So, you know, courts are there to be used, and courts have more power. Arbitrators only have the power you give them. And maybe things come up that you need a judge for. So again, it's super important to get legal advice on this early.
Perfect. All right. So moving along to another option, mediation. We've mentioned mediation, but we haven't really formally gone into what is mediation? When does it happen? When should we consider it? And does it help you even if it doesn't resolve the dispute?
Well, mediation is basically a facilitated negotiation process with a third party. So a neutral or impartial person helps you come up with your own solution. And that's one of the keys, is the mediator can't impose a solution. So it's really a negotiation process. And, you know, Christy would see it from a different perspective I do as counsel, but certain disputes you have to mediate under the Condominium Act. What it can do for you is quite broad, and I think I would lump those two questions in together. It can help you understand what the other side's case is really driven by, and it can also help you look very reasonable. So there's a couple of different things there. But one of the problems with mediation is if you're just going to mediation because you have to and you're ticking a box, you're not likely to get what you want. And I see that happen sometimes, and the level of preparation is not where it should be. So you really need to decide on what you're doing. Again, going back to what I said about litigation, am I just going through this because I want to arbitrate the case? You know, and if you are, and the other lawyer is someone you can deal with easily, it's probably worth asking them to just move it ahead. Because if you're not serious, you're not going to get a lot out of it. On that flip side of that is, anecdotally, between 70 and 80% of mediated disputes settle. And when they settle, they tend to stay settled. They can be much more sustainable in terms of people kind of stick to the deals they make. So there are huge advantages to it.
And so we were discussing about the briefs you receive and how
that's preparation.
Yeah, that's preparation.
You know, one of the things we have to remember, and this goes right across the board, is to a mediator and in mediation, what's really important is getting people's interests. It's not law. It's not really evidence-based. It's information-based, and it's an opportunity to discuss, right? Many mediation briefs are quite legalistic. They tend to follow the same kind of process they would in a court, but they're not fine-tuned. They're not focusing. They don't say what people actually want in the mediation. They don't give opportunities. They don't take opportunities for persuasion. And again, this is important when you think about who you're writing for. Mediation briefs are being written for the other party. Okay, they're written for the lawyer, sure, but they're really written for the other party. And this is a great opportunity for you to get your case in front of the other party, even though they'll have talked about it with their lawyer. When they see what you've said, even if it's in court, if there's a statement of claim, your lawyer is probably going to say, oh, don't take that too seriously. It's just statements, and we have to prove it with evidence, or they have to prove it. But the mediation brief can be the first contact point where somebody actually sees strengths and weaknesses, because it is sent to the client, and that makes the effort worthwhile, right? So mediation, and they should be brief, by the way, but they shouldn't, you know, be massive unless you have to do that. But they should be more focused, and I think that would help. Now, will it bump the settlement rate up? Probably not too much, but what it will do is will make the settlements better, more comprehensive. And I see that in the type of process I do, a process that brings mediation and arbitration together, higher success rate in the mediation and very little left behind. They tend to be much more integrated resolutions. So Christy, what do you think?
So I guess what I would say about the briefs is, just on the point about the briefs, is I do agree with you that it's an opportunity for parties to really persuade the other parties of their position, as well as the lawyers. I will say, as a lawyer who engages in mediation, I like getting the briefs too, because it allows me to see what the position of the other parties is. And so I'm able to better advise my client on settlement. So if I know where my weaknesses are, which I'm only going to know, well, I mean, I might know anyway, but if another lawyer is laying it out in a persuasive way to me, then I'm able to then advise my client on where those weaknesses lie, how strong our cases versus theirs, and what our settlement position might be in light of the position being taken and the evidence that supports that position, which presumably they're going to go through in the brief. So and again, it goes back to preparation, as you said, Colm. It's the briefs are like the product of the preparation, but in preparing the briefs, you really get an opportunity to assess what your position is, and then the strengths and weaknesses of everybody else's position compared to yours, which is what is going to inform everybody's settlement positions.
Yeah, oh, that's interesting. So there's all kinds of reasons to mediate. I mean, besides which it's often mandatory, but it's never really a waste of time if you're learning so much about. I mean, if you're doing it correctly, if you'll be learning a lot about the other party, and you'll be listening, and I imagine too, Colm, sometimes people leave those meetings and think about what was said in it, and might still be, after a few days of letting it set in, maybe their attitude changes even after the mediation.
For sure. I mean, it's very hard to define success because, you know, what do people need? What do they want out of it? But there's no doubt that in the time period after the mediation, a significant number of cases resolved for a couple of reasons. Both parties have heard the other. The lawyers have had a chance to look at the other side from the perspective of going further. And even more importantly, people have started thinking about settlement. And they see where it's going. I mean, I tend to follow up on cases don't resolve, and a good chunk of them do in the next 2 weeks because everybody's focused on it. Lawyers are very busy, and litigation lawyers are even busier. And so they've got a lot of cases, and they have to manage them all really well. And so although they give attention to every case, they focus when they're at certain stages. And the mediation is the stage that focus really pays off. And it may lead to settlement, or at the very least, if you have several issues, you're likely to settle some of them, which will make the next stage, the next step, more efficient, more effective, and not as costly.
Well, makes sense. And speaking of possibly the next step, our next slide is the next step, or a next step. And I wanted to say quickly, I put this picture here partially because I found it amusing. I did a search for arbitration photos and wanted to know what people thought arbitration was like. And apparently they think there's a gavel involved and that it's a court hearing. And I don't think either of those things are accurate, but they are amusing. So Colm, how often do you use your gavel, and what is arbitration like?
Well, I'm going out to get one after this because I'm so impressed with it. Yeah, I mean, we don't use gavels. Judges don't use gavels in Canada, and certainly arbitrators don't. Nor is it a court hearing. It's quite different. Arbitration is not a form of litigation. It's a private dispute resolution system. And one of the big pluses on it, and it's mandatory in condos, if mediation is mandatory, then arbitration will be. It's often in agreements and contracts, and that might cause more problems sometimes because, again, people don't think about what type of dispute they might want to deal with. Is it more expensive? It appears to be, but the real question isn't, is it more expensive than mediation? The real question is it more expensive than litigation? So there's, again, very little data. That's a huge problem. But a survey by the federal government seemed to say that arbitration could result in 50 to 70% less costs if it's structured right. So it has its pluses for sure, as long as you don't think of it as being litigation, and as long as people are willing to design it to the dispute. Lots of scope there you don't have in court. The flip side is the arbitrator can only deal with the issues that the parties give the arbitrator permission power to deal with. So there's nothing outside of that. So it's very narrow.
So maybe a little quicker, but less robust than litigation.
Oh, no, it's not less robust.
Maybe
it's
that's not
just
the right word.
not as wide. I mean, it's quite
Okay.
robust in the areas that you're given power on. I mean, an arbitrator can even rule on whether they have the power to do something. Okay, the Arbitration Act is just there. There's a few parts you can't contract out of, but otherwise everything is private. I mean, how do you want to do this? So it can be very robust. It can be efficient. You can do things around witnesses and how you're putting evidence in that are just so much more streamlined than litigation. So robust, I think arbitration, well designed, well run, can be very robust.
All right, I take it back.
Okay, I'm glad you did.
Christy, we're coming up against 1 o'clock. We have one more slide about the Condo Authority Tribunal. Keeping that in mind, and my apologies, did you have anything you wanted to add about arbitration before I?
No, I just wanted to echo Colm's comment that one of the reasons I like arbitration is the flexibility around the process. So the authority in terms of the substance, the subject matter is, as Colm said, whatever it is the parties give to the arbitrator in terms of authority, but the process can be designed by the parties with the help of the arbitrator. So it can be, you can do all kinds of different things through arbitration that you can't do in the court process. And the other thing I want to mention is that at the end of it, sometimes people don't appreciate this, but an order from an arbitrator is just as enforceable as a court order. So it's the same thing. It's just a different process. And I suspect it's going to become more and more popular as the courts get more and more jammed up.
So you can arm wrestle to see who presents their case first, I guess, if you wanted to.
That's part of the negotiation and process.
In theory, you could.
So, okay. So how is the Condo Authority Tribunal changing this in Ontario? Briefly too, I suppose this is something BC is farther along in. Colm, did you want to talk about how this is changing the mediation landscape or the arbitration landscape?
Well, it is changing it because the tribunal has increased its powers, its jurisdiction quite widely. The way the reforms were put in place is the tribunal essentially has exclusive power to deal with all condo disputes, but they only take bits at a time. And they've taken a couple of big bits recently. Big bits being things around pets, around noise, nuisance, all those things. So they don't go through mediation in the old way, which in many ways is good, because many of the mediations that are those kind of issues should never get to mediation. They should be resolved. Where it will go, it will increase its jurisdiction. I mean, they will increase the size of the tribunal, it'll increase it. There now has been a case with legal fees have been awarded at a reasonable level, which I think was a huge issue, whether it could do that or would do it. So, lawyers will be more involved, I think. But property managers and paralegals and other agents are really involved in this. So I think it's important. In the end run, I don't know. I'm still waiting to see what happens with more complex disputes in an online environment. And I'm someone who's very supportive of online dispute resolution, but I'm wondering about how it's going to be dealt with. But it's certainly here. It doesn't say a lot about itself, but feedback seems to be that people are relatively satisfied with it, who are the users of the system. It's a slightly different system than the Civil Resolution Tribunal in British Columbia, because the one in Ontario is fully online, and the one in BC started with Strata. It deals with all kinds of Strata disputes. It also essentially does small claims court and some insurance work, and it's really broadened out. I mean, if we're looking at the future of courts, this is what courts are going to look like in the future. not just putting technology in the existing courts, but totally
You mean
redesigned.
this photo is what courts are going to look like?
It is. They're going to look just like that, and I appreciate you went to the trouble of finding that. I don't know if that's, Captain Kirk is telling the truth, you're going to be electrocuted, but either way, it's a good thing. And Star Trek was
Oh,
a
boy.
great series,
Yeah.
positive, and there's mediation in it too. So
Yeah, they like to have these very heady episodes with mediation and even sometimes litigation. So Christy, about the Condo Authority Tribunal, just to wrap up, what has your experience been with it, as far as how has it changed your practice, I suppose would be the question.
Yeah, so it's as Colm mentioned, there's sort of specific issues that can go to the tribunal right now that will likely be expanded over time, but within the realm or the scope of those particular issues, generally speaking, what I will say is that I think the tribunal does provide for a relatively efficient and a relatively efficient process. So it's quick. It's not super expensive if you do decide to engage legal counsel, which you don't have to do. And then on the flip side, sometimes when you're dealing with a more abbreviated process, and one where lawyers are not necessarily involved, there can be a consequence to that in terms of the substance of the decisions. But I have found that the decision-making from the tribunal has been pretty sound in most cases. So I've been actually quite impressed with it. I will say, I don't know that if parties want to mediate, they can still mediate. They're not required to go to the CAT. So mediation is still an option. There is a negotiation process and then a mediation process built into the CAT process. But it's a little bit different because it is done sort of in writing for the most part. And so if parties sort of want to avoid that and they're interested in mediation, it's something to keep in mind.
Great. Okay. So I guess I will just leave it at concluding thoughts, if any. We don't have any pending questions. If someone does have a question, you can feel free to type that into the Q&A box in the Zoom meeting. But Christy, I'll go to you first. If you have any concluding thoughts about dispute resolution and condos, what we can take away from this, I suppose.
I guess the main thing, I mean, this is the theme that's run through our presentation, is the need for reasonableness. And as part of that, I think empathy is a big component. So just understanding the people that you're sort of arguing or fighting with goes a long way. Just trying to understand where they're coming from and what their motivation is I think if you take nothing else away and you take that away, it might help you in some cases resolve a few disputes rather than allowing them to escalate.
Great, thanks. Colm?
Yeah, I think realize that each conflict or dispute is different, even if it have echoes of the past in it, including the people. And take a wee bit of time moving forward. Don't jump the gun, because the consequences of it can be very, very bad for the community in terms of the community itself, but also in terms of costs. And as I've said, I've found a number of times in arbitrations where they have to special assess for costs. And that's not good. And some of them could have been avoided if they'd gone down a different path. So consider the path. Get advice from Christy on which path to go down. Gerry, you tell them which path to go down if it's not going into court, because you know that. And you can ask Christy. But I think condo managers and lawyers are resources that are not used enough at the beginning of things, at the beginning of conflict. And from my perspective as a former lawyer, but somebody who does, see a lot of different conflicts, about a third to 40% of what I do is condo, but I do a mixture of other stuff. And in the other stuff, for want of a better word, people do think where they're going. Where in condos, there tends to be more of an emotional reaction. And I understand that because of the nature of condominiums themselves. So think before you act. Yeah,
I think my concluding thought would combine all these things together, and that I agree. Reasonableness is the strain running through this. And I would also just remind people that when you're acting, I guess this is more to condo managers, but really it does apply to everybody. When you're acting in a condo, remember you're interconnected with other people. You have a trust situation, perhaps, you know, you're fiduciary to somebody almost all the time, right? So if you're a manager and you've gotten a complaint from an owner, that isn't a problem. That is why you're there, is to deal with it. Even if the owner is difficult, try to pull out the kernel of the complaint, and remember that you know, this is a corporation that needs to operate in a reasonable way, and try to divorce any you know, history from it. Just like Colm, you were saying, just start afresh each time as much as you humanly can to just do what you're supposed to do. And I think I will leave it at that, and thank both of our speakers, Christy and Colm. Thank you so much for agreeing to do this webinar. And I will thank our sponsor again, Atrans Council, and thank you again to CAI Canada for putting this on. And have a good day.
Thanks, Gerry. It's a pleasure.
Thanks, Gerry.